Morning, Brian.
Good morning, Mark. How are we this morning?
Brilliant. Absolutely brilliant.
Good. So we've got a nice little update this morning, and some re-clarification of what's been done already, I suppose. Simply. So let's just jump straight in because this might take a while.
Yeah.
And we've got some
good news.
Interesting stuff.
Yeah.
I always get excited when something happens, and we've got to share it with people. So
yeah, no, brilliant. Okay, so what I want to do is just go back to basics first. Okay, because it's important that people understand the simplicity and the basics of the, of what we're dealing with here. So I just want to review, and then the idea of this is to review what we've learned so far with the knock-knock challenge. So the first thing I want to do is start with what is a bill, okay? Because it all starts with the council tax sending you a bill.
Yeah.
So basically, this is the etymology of the word bill, and a bill is basically a formal document, plea, or charge in a court of law, okay? And so it's a written statement of a belief. And to bill somebody is simply to send somebody with this charge. And then with the free dictionary, so this is the modern version, okay, affirms an itemized list or statement of fees or charges, which is exactly what they're doing. But I just want to quickly mention, people are familiar with bills being proposed into Parliament.
Yeah.
Again, that reaffirms it's a bill, it's a claim, okay, and we'll see this. So in law, it's a document containing the formal statement of the case in equity. Okay, now equity is important here. A complainant is seeking equitable relief. Okay, and so billing is just a presentment of that. So from that, it's clear council tax bill is nothing more than a claim in equity of their belief of an entitlement. As the complainant, they believe they're the creditor, and another is under an obligation to settle it, you, who they say is a debtor. So now, basically, under the court's rules and that, everything is based upon the evidence before the court. Terry, no. Right. So what I want to do here is just take you to this, but essentially, so that you can see for yourself, the court can do nothing without evidence. Okay? So what we're saying is, under the court's own rules, the claimant must bring the witness in that can provide first-hand cross-examinable testimony, okay? That one person has the right to impose their will on another, okay? And if they cannot do that, that there is knowingly causing another harm. And hence it's self-evident. All are equal under the law. Nobody's above the law. And he who asserts a right must prove that belief. Okay, so let me just share this so you can see it for yourselves in the rule book.
Yes.
Okay? Because it's about following the evidence.
Always.
So this is the Magistrates Court Act. And we solved the story. If you try going to a magistrates court, it's only for criminal cases. Okay, so this is the Magistrates Court Act 1980, and Control Plus. Okay, I hope you can see now.
Oh yes.
Magistrates Court have criminal jurisdiction as well as civil jurisdiction. Okay, so if we look in the civil jurisdiction, how does this work? Okay, so basically, the first thing is that the complainant makes a complaint. And this is how they make a complaint. The council is claiming, and they're writing down, we've sent somebody a bill, and we believe we're entitled to it in accordance with the legislation the Local Government Finance Act 92,
Yeah.
and the Admin and Enforcement Regulations in 1992. So you issue a complaint to the Justice of the Peace. Okay, so any person, okay, the complaint is made to the Justice of the Peace. Looking at that complaint, the Justice of Peace may issue a summons to the person requiring him to answer to the complaint. Okay, so a complaint is made and we are answering to that complaint before the Justice. Now, the reason we need to deal with this when the bill comes through, okay, is we must be able to show we've done everything to try and deal with this matter in private. If we've done everything humanly possible in private to deal with the matter, and they have not provided full, accurate, or complete response to our notices, that puts them in inequity and dirty hands. And even though you get summoned, if you've done your paperwork right and you can evidence that they've not responded and answered your questions, then the court has costs are not always awarded against the either party. Costs are discretionary of each court. So if you do your paperwork right and can show that they were inequitable, i.e. with unclean hands, remember the bill is equity, then the court cannot award costs to the councils. So then, and the court then, with its jurisdiction, it can hear any complaint. Okay, and then they've put in here, unless we at Parliament say that you can't. Okay, and this year, as we'll see when the court auditor course comes out, is actually a contempt of court. So next section deals with the complaint itself. Once you're there, how does the court deal with it? So on hearing the complaint, if the defendant appears, the complainant states the substance of the complaint. The court, after hearing the evidence of the parties, i.e., it must hear the evidence, shall make the order for which the complaint is made or dismiss the complaint. Okay, where a complaint is for a sum of money recoverable as a civil debt or a variation to periodical payment, the courts, okay, the court may make the order with the consent of the defendant without a hearing. Okay, so the point here is a civil debt. And this is the situation that we're in. Somebody's making a claim that we're a debtor and they're a creditor. So under the Magistrates Court rules, this gives us more clear the procedure. And so that's section 14.
Just increase the size a little bit.
Yeah, let me just find the piece that one first. Okay. Okay, so this is section 14 of the rules, the order of evidence and speeches. So first, on hearing the complaint, except in that circumstance, i.e. where they've made an agreement, we don't need to hear the evidence, we accept it in writing, the complainant shall call his evidence. Okay? And before so may address the court. So basically the may address the court is basically a summary of the case, what the claim is or complaint is, and then they shall call their evidence. Remember, shall is mandatory. If there's no evidence, the court can't include that.
Right.
Once they've done that, the defendant may address the court, whether or not he afterwards calls of evidence. This here is where you're cross-examining the evidence that they've presented. Then you present any further evidence for your cause. At the conclusion of that, for the defense, the complainant may call evidence to rebut your evidence. Once he's given their rebuttal, you get the final say, unless one party asks for another round to rebut. And it always ends up with you as the respondent having the final word.
Yeah.
So this allows both parties to make sure that the court understands both sides of the story. And this is where it comes from. The last unrebutted statement on an affidavit stands as truth, and therefore becomes the judgment. So here's exactly that procedure. Is what the courts should be following.
Extremely clear.
Very simple. So, so this is what we're saying then, is you making a claim in equity that I owe you money, and you've sent me a bill, and your bill, because we've not managed to settle this matter in private, you've put in a complaint for public dispute resolution, and it's the same procedure, what we're actually trying to do in private. They send their claim, we're sending a rebuttal. If they don't rebut our rebuttal, now they're breaching our peace. We send them a reminder, we send them a final notice. That's what they do. They send you a bill, a reminder, and a summons. Okay, so it's exactly the same thing. It's a mirror. What they do to us, we're just reflecting back to them. We expect the same. Treat others as you wish to be treated yourself. So this here then is the simplicity of all that we're doing. Until the debt is established, basically, there is no obligation. So because nobody can prove authority to cause another harm, all interaction can only be by consenting to respective duties, rights, and obligations for any interaction.
Of course.
Okay. Without consent, nobody can prove authority to impose their will on another. Causing another harm is known as a breach of the peace, and a breach of the peace can be against a person's mind, that's a fraud, against a person's body, that's a crime against the person, or against a person's property, which is a crime against property. Okay. And legally, the Interpretations Act 1978 defines a person as person includes a body of persons, therefore it can be singular and plural, corporate or unincorporate. And the 1889 in the brackets refers to the Interpretations Act 1889, where person was first legally defined exactly as it stands now. What does corporate mean? To legally form a body politic with perpetual succession and power to act as one person, established as a legal corporation. So literally, you are setting up a fiction of law, a legal fiction, a straw man, corporation, and living people choose to become a part of that corporation. So therefore, a person means an individual or more than one individual, and they can be unincorporate, which is a natural person, which is acting in your private capacity, or a fiction of law through incorporating themselves legally, an artificial person or public capacity. And then all of those harms are common law torts of trespass against the mind, the body, or property. So that's the foundation of what we're doing here. And that's how simple it is. Prove your right and my obligation. The government, Parliament assembled, governance is a public incorporated body. That does not mean it's a for-profit private corporation. Okay. And so people keep going to Dun & Bradstreet and Companies House and say, oh, look, a for-profit corporation, and the court's a for-profit corporation, and that. But when you actually look at the detail of the registration, it's actually public bodies.
Yeah.
Okay.
Yeah.
So it's just a way of structuring rationally and identifying whether you've got a legal person or a private person, i.e. public capacity or private capacity. That's all that it's about. Okay. So hopefully that is explained essentially sui juris, in my own right.
Yeah.
Until somebody can prove authority over me, then nobody can do me any harm. The only way that they can prove authority of an obligation is by consent. If there's no consent, forget it. There is no right or obligation. So with that, hopefully people really understand now that unless we consent, and he who approves must assert, they must prove their belief, then there is no obligation. And if we can't settle the matter in private, it goes to the public dispute resolution, and based upon the evidence and the evidence alone, they cannot, they must reach their decision rationally. So what's happened largely is that in the magistrates court, there's a couple of things where they actually are acting unlawfully. So I just want to go back to the Magistrates Court Act. Hang on, let me just first show you what's lawful, what should lawfully occur in the courts.
Yeah.
So this is from, it's in the Court Auditor Manual as well as in the Peacekeeper Manual. And basically, the first thing is that people need to see. They talk about the Royal Coat of Arms, and this here actually again is from their own websites, all right? The Royal Coat of Arms appear in every courtroom in England and Wales, with the exception of the Magistrates Court in the City of London. That's because that is a different jurisdiction.
Of course, yeah.
Okay. Demonstrating that justice comes from the monarch, and a law of court is part of the royal court, hence its name. Judges and magistrates are therefore officially representatives of the crown, okay? Not of Parliament assembled, not of Her Majesty's government. They are directly part of the crown, one branch, as is governance. That's a different branch of the crown. So the presence of the royal arms explains why lawyers, court officials bow to the judge or magistrate's bench when they enter the room. They aren't bowing to the judge. They're bowing to the coat of arms to show respect to the Queen's justice. Okay? So this here very clearly says it's a separate branch that there's created by the second promise of the monarch, and the independence is given to the Lord Chancellor, who's got one job: defend the independence of the judiciary. Therefore, the judiciary is not subject to acts of Parliament. Parliament has zero authority to tell the courts what to do. And then all of the judges and magistrates, they make an oath to do right to all manner of people after the laws and usages of this realm, without fear, favor, affection, or ill will. So then the law is enforced by the police constables, okay, with all fairness, integrity, diligence, blah, 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 to cause the peace to be kept, preserved, and prevent all offenses against people and property according to law. Okay, nowhere here does it say statutes or acts of Parliament. It's law. Okay, so I quickly want to show you now what law is.
I just want to go back to the first few words: cause the peace.
Yeah, keep the peace.
Let's keep the peace. And so many people still do not realise where all these interactions stem from. It stems from a breach of your peace. Someone is disturbing your peace. Yeah. Balance has to be restored. So peace has to be restored.
And that's what it's all about.
And balance is equity.
Yeah,
it's
absolutely.
Really, it's that simple.
The scales of justice.
Equity.
Yeah. So, hang on, where was I going with that? With the independence. Oh, back to the Magistrates Court Act. So, Parliament has created the Magistrates Court Act. Okay. And what they've done is they've tried to usurp the independence of the judiciary, and they've legally expressed this. So if we could just go back to the contents. Okay, section 101. Okay, so this is evidence generally. Hang on, let me just pull up the whole few paragraph sections here into one again to reinforce. Okay, evidence generally. Okay, so basically evidence on oath, unless elsewhere prohibited by an act, again, they are trying to interfere with the courts. Okay, or the rule of law, which we'll look at what is law in a minute. The reception of unsworn evidence for the magistrate's court shall be given on oath. Okay, so if you don't make a statement of truth of that on paper, it needs to be given on oath. Proof of the sum adjudged, where the court has ordered, so we're not interested about that because this is after the fact, after the liability order. However, here at section 101, onus of proving exceptions, etc. So what Parliament's done is with this, they're trying to usurp the fundamental principles of law. All are equal under the law. Nobody's above the law. And he who asserts the claim must prove their claim. So what they're saying here is when there's an enactment, okay, a complaint made by an enactment, which creates the offense, the burden of proving the exception, exemption, proviso, excuse, or qualification shall be on me, the person that's trying to defend myself. So this here is a clear contempt of court and direct abuse of power, because what they're saying with this is you're guilty of a complaint unless you prove yourself innocent. Okay, now that's so important, and that there needs to go, because that there is totally against the fundamentals of law. Okay.
Yeah.
However, because we actually are using exactly that legislation to prove that their actions are unlawful by sending that bill, that there is how we actually are now managing to bring legislation and debates about legislation and law into evidence before the court.
Yeah.
Before they just said, legislation is law. End of.
That's it.
Under our right, even granted by Parliament, to prove an exception, okay, they now have to listen to us.
Yeah.
So they've gotten away with this for far too long.
Yeah.
But I just want to go and show you then, there's a legal definition of legislation. Settlement Act 1700. And thank you, whichever council put us onto this.
Yeah.
And interestingly enough, the council was using this to try and assert their claim or their belief, and they totally misinterpreted.
That was Malden, wasn't it?
I think it was Malden.
Yeah, on the OPCA.
I can't remember, it doesn't matter. Yeah. But basically, it says here the laws and statutes of the realm confirmed section 4. And this here absolutely annihilates and settles any dispute as to what law is.
Oh dear.
This is their own, this is Parliament telling us what law is.
Yeah.
Okay. So in the first sentence, the laws of England are the birthright of the people thereof. Okay, very clear. The law is our birthright, i.e. from a higher source, but doesn't come from there.
No.
And it goes on, all kings and queens who shall ascend to the throne of the realm ought to administer the government of the same according to the said laws, our birthright, and all their officers and ministers to serve them accordingly to the same. So not only have we got here a legislative admission that the definition of law is our birthright, we've also got in there all of those governing must govern according to our birthright.
Yeah.
So this alone just totally annihilates the whole lot.
Yeah.
Okay. So with that, the other thing, sorry, that I was looking for was Lord Diplock with the, hang on, this one here. Okay. Let me just reset this so I can quickly find it. Okay, sorry, just bear with me for a second. All right. Okay, the due process of law. Okay, we've seen what do the courts of the rules, what do the written rules say it is. Okay, so this here basically then is, oh damn, yeah, here, the due process of law. Okay, so basically this is common law precedents, Lord Diplock in Attorney General versus the Times in 1974. And he defined, so this is what the rule due process of law is. Everybody has unhindered access to the constitutionally established courts for the determination of disputes as to their rights and liabilities. Exactly what we're talking about. Prove my obligation and your right.
Yeah.
It must be free from any bias against any party and will be based upon the facts only that have been proved in evidence deduced before it. Okay, so that reaffirms what I was saying. And in accordance with the procedures adopted by the courts of law, so I've shown you in their own procedures, it can only be based upon the evidence. No usurpation by any other person of the function of the court to decide, but according to law. So there's no question the rules reflected are, the written rules are also the common law as to what should happen.
Yeah.
Anything which is to the prejudice of that is a contempt of court. So as soon as they deviate from this, which is expressed in the rules which reflect this, that's a breach of abandonment of office.
Yeah.
Okay. So the other thing that people have an issue with is this issue of natural justice, natural law, etc., etc. So with that, again, let me just find that. Oops, contempt of court. Let's see. Yeah. Okay, well, when I find that, I'll come back to it. It doesn't matter. But basically, a contempt of court is very, very simple. A contempt of court is anything which in any way may tend to prejudice a party of the case. If they do not follow the rules, then they are in contempt of court. If they're misleading, claim things that they don't have a right to, etc., it's all a contempt of court. Yeah. So what's happened so far, right? Basically, in the private, they've sent us a bill, and we've responded and said to them, until you can prove your claim, I'm withholding any payment.
Yeah.
So never has it been said that we are refusing to pay.
Never.
Okay, that's the first thing. What we're saying is, in accordance with the rule of law, the court's own rules, they must prove their claim. And basically, we've had full responses from basically, bugger off, we're not even entertaining this. The full spectrum to, and I take my hat off to the guy at Chichester Council, where he's actually really tried to address it.
Yeah.
And you could see he was applying their mind.
Yeah.
And then we've had everything in between from, you guys are a bunch of idiots, and Opka and Freeman of the land, and this nonsense. So once they've responded to we've responded to their notice, i.e. we're rebutting their claim, asking them to prove it, their right and our obligation. They've then responded. Where they've responded, then we've rebutted their rebuttal of our rebuttal. And then we've narrowed down the issues. And essentially, not one of the councils can go beyond essentially Local Government Finance Act 1992.
It's pathetic.
And they call it parliamentary sovereignty.
Yes.
I.e. Parliament is the supreme maker of law.
Yeah.
Okay. So let's just look at that. Is that true? Because this is the essence of the rebuttal.
Yeah.
Okay. So admin and finance. Let's get rid of this thing at the top. Council tax administration and enforcement. Oops. Regulations. Well, I was going to say no, I can't find it. It's going to be faster like this. So the basis of the claim is what gives rise to the bill is the admin and enforcement regulations. And so if we look at this, we're looking for authority. So in the introductory text, it'll tell us the authority of this claim of theirs. And that says, Local Government Finance Act 1992. Okay, so they're saying this document upon which they're sending their bill out gets its authority from the Local Government Finance Act 1992. So let's just go to that then and see where that gets its authority from. Okay, so we go to the introductory text of the Local Government Finance Act 92 to see where it gets its authority from. Okay, and what have we here? That there's where it gets its authority from. Be it enacted by the Queen's most excellent Majesty, by and with the advice and consent of the Lords spiritual and temporal and commons, in this Parliament present Parliament assembled, and by the authority of the same.
Unbelievable, isn't it, Mark?
Okay, so by their own authority,
Yes.
they are creating their belief of a right and our obligation. Okay, so so essentially that's the foundation of it all. Nothing. By and with the advice and consent means meeting of the minds, consenting to respective duties, rights, and obligations. So any duties, rights, and obligations within here are according to Lord Spiritual, Temporal, Commons, and the monarch. Nothing to do with you and me.
Nothing. No.
Nothing at all to do with you and me.
It'll take a while to get people's heads around that, I think. But
and this is why what they try, once this is pointed out to them, then they're basically running to parliamentary sovereignty.
Yeah.
Okay, so let's look at parliamentary sovereignty. What created Parliament? So, 1688. So let's slow my internet. So basically, Parliament has said by their authority they've created this belief. Come on. Nothing worse than a slow internet. Here we go, moving now. Okay, so the first act of William and Mary was to create the legal fictions, the fictions of law, the incorporation of a group of people. Okay, so basically what they're saying, an act for preventing all questions and dispute concerning the assembling and sitting, okay, of this present Parliament, so that we have no more doubts and scruples. It's declared 2 houses of Parliament. The Lords Spiritual and Temporal and Commons convened, okay, and following them convening, they declared and enacted and judged to be all constructions and purposes, whatever, notwithstanding any writs, blah, 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 blah. They've granted themselves authority. So that there's the creation of the legal fictions. Okay, so this creates the legal fictions of Lord Spiritual, Temporal, Commons, and the monarchy. And then if we go back to what gives the authority, we go to the Bill of Rights. So first they had to create the fictions of law, Parliament assembled. And then the Bill of Rights is the instruction manual of what they can and can't do.
Yeah.
And people need to start reading this.
Bill of Rights, isn't that like a contract to the people then?
No. And it's no different from when you set up a company on Companies House, you have a constitution. This is the constitution, the constituting authority. And you can use different names for it.
Yeah.
Oh, come on, the internet. Right. So if we look at the Bill of Rights, we'll open the whole act. And let's have a look at this. So the Lords Spiritual, Temporal, and the Commons assembled at Westminster. Their claim is to lawfully, fully, and freely represent all the estates of the people, i.e., who's the master and who's the agent. Okay?
Yeah.
People create fictions, and this is the admission that they are representatives of the people, which makes it a principal agency relationship, and they can do nothing without our authority.
There you go.
Nothing without our consent. Okay.
Mm-hmm.
So this means that it's only, and William Blackstone, and it was really pushed by Dicey after that, is that, I know, but we can't all make rules and laws. Somebody's got to make them. Okay. So because all are equal under the law and nobody's above the law, what they claimed is to be representing. Now, even to get 10 people to agree something is a problem, let alone 67 million. Okay. So therefore, nothing they can do is, they can't do anything to the prejudice of the people. No doings. So within here, they constrain themselves. We've got to do a separate thing really on this. Control, fine. No, do. Yeah. What it says here, okay, no declarations, judgments, doings, or proceedings to the prejudice of the people in any of the said premises ought in any ways be drawn here after into consequence or example. Therefore, what's listed here is vindicating and asserting their ancient rights and liberties. And we've seen in the Act of Settlement 1700 that there is the people's birthright. So they can't do, that's expressed in the Bill of Rights. Therefore, they can't do anything against our birthright. So this here, next one, dispensing and late dispensing of the powers. This here dismantles the whole nonsense of the separation of powers between the legislative body, the executive body, and the judiciary. Okay, this document is created, governance is created by the first promise, the judiciary by the second promise. But what this says is, Her Majesty's government can't do anything without authority of Parliament assembled. It's illegal. Okay, and they must do it when the Parliament tells them to do it. So you've got a principal agency relationship again. So we've got the people at the top. They tell the representatives what to do, and the representatives tell Her Majesty's government what to do. They also have to ensure that there are no ecclesiastical courts. They can't levy money for the crown. Okay, so the crown with an E is the trustee, the monarch. Okay, so the monarch can't get money for their self-interest without the approval of Parliament. And the right to petition, it doesn't say on a Saturday, Monday, Sunday, Tuesday, rainy day, sunny day, or here, there, or anywhere else. It's the unrestricted right to petition. And then it just goes on armies. But here, subject arms, this is the Second Amendment in America. Also, that subjects which are Protestants may have arms for their defense suitable to their conditions as allowed by law. We, the people, create the law in the courts. I'm not interested in elections because elections is for basically mafia rule. Excessive bail is basically until you receive trial, they can't inflict any excessive fines or impose any cruel or unusual punishments. But the jurors must be impaled and returned, and grants and forfeitures cannot be made before conviction. So the jurors create the conviction, and therefore any court without a jury is unlawful. Then, and this is affirmed actually that it's all about equity in the Sentencing Act 2020, which we'll talk about separately. But basically, nowhere in here does it say they can steal the money from the people. I can't see it.
No.
And under their obligations, they can't do anything to the prejudice of the people. And by trying to steal my property and the fruits of my sweat equity, my money, okay, they have no lawful right unless it's consent. So under the rules of the court, that's what we are doing. We're asking them to prove the rights. So with one of them, with John, basically the judge tried to say, oh, but how else is the council going to take their money? Provide the services. Quite simple. In a court of law, you're talking law. Therefore, the council, how it gets its money, what it wants to do is a political or social issue. It's not a matter of law.
No.
Okay? Not before the court. Therefore, it cannot influence the decision of the judge or jury. Okay, so what have we learned actually physically so far? Most of them don't engage, and then they just end up in default going to summons.
Yeah.
Okay, and taking it to court. The first problem that we've had is that the courts, okay, now remember, courts are fictions. Through their agents who are implementing security at the courts, are denying the public the right to the courts.
Yeah.
Okay, so in the court auditor manual, this is covered, but essentially with that, we've been put, in my case, we've pulled the security guard up. We made a bit of a stink in front of them in the public waiting area. And she refused to give her name and ID number.
Wow.
So we pulled the law on it, and she got very shirty and called up some security officers. And I said, no, let's get the manager, because those guys don't know the rules. The woman in the court, the usher, came out because of the noise outside and asked what's going on. And we said, this person is denying the public access to the courts. We've shown her the law, and she's still refusing to abide by the law. And so she just turned around and said, sorry, you got to let them in. Okay.
Yeah.
So once we got in, we were sitting in the public gallery, and there was a guy before us who was through the being heard. And basically, what had happened in this case, it was scheduled for 10 o'clock. They didn't have any people allow people to defend themselves before. They made the liability order or orders for the batch. So what they did was denied anybody the right to defend themselves. Only through the council representatives and the clerk and the court, they went through the evidence and made the liability order upon that. And thereafter, they said, a liability order has been made against you. What are you going to say about it?
Wow.
Okay. So the first thing we said is, well, how on earth have you reached that decision? Because I've been waiting outside since 10 to 10, and I've not seen any evidence, and you've denied me the right to see the evidence and to cross-examine the evidence according to your own rules. Therefore, any order you've made is void ab initio. It's got no authority. And then they got into a thing, oh, no, we didn't know you out. That's not my problem. We checked in with the usher. And it reached the point where I just said to the magistrate and the clerk, are you calling me a liar? You want me to go out there and pull in some witnesses here to say they saw me at that time? And then they backed down on it.
Yeah, I bet.
Okay. And then I asked, what is the case number? They had no case number.
No.
So if you've got no case number, how on earth is this a matter before the court? Again, no authority of what they're doing. So then basically they were trying to whinge out of it. And with that, first representation, Ahmed came with me. So we were sitting in the public gallery. We then, when the guy before me, they finished with them, they called me in. And so I said to Ahmed, just come along. Okay, and as soon as he sort of stepped out of the public gallery, the clerk was like, no, 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 stay there. It's him we want. And so we tried to speak, and they were speaking over us. And so I said, okay, Ahmed, just hang on a second. And he just stayed there. And I just turned around to the court and said, who are these two gentlemen on the left here? Are they from the council? Are either of them officers of the court? No. Ahmed, yeah. You've set the precedence that you don't need legal representatives. And therefore, your precedence in this court is you don't need legal representatives. Ahmed came, not another word was said.
Wow.
Okay.
Yeah.
And then basically, while they were trying to whittle out of this nonsense, they asked sort of, what's your problem? So basically, I started pulling the papers out and put like the Act of Settlement, Bill of Rights, blah, 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 out. And the clerk was like, oh, God, another freeman of the land. We've heard all of these arguments. He actually said to the magistrate, we've heard all of these arguments.
Really?
And they don't hold up.
Really?
So I said, no, my friend, I'm using your legislation. This has nothing to do with freemen of the land.
Yes.
Okay.
Yeah.
And then basically they got really, concerned. And the clerk actually admitted, yes, I've seen your email to the court.
Oh, really?
Yeah. So it's important we make sure we email the courts as well as
the
councils. But essentially, my first complaint was these guys haven't bothered to answer any of the questions to prove their claim in my obligation.
Yeah.
And then I started reading out, they sent their bill on this date. I sent them caution notice on this date, asking, no response. Reminder notice, no response. Final warning, no response. Summon received. These are caution notice, no response, no response, no response. And so basically, the two guys from the council were just mute, as if they weren't there.
Yeah, of course.
So the clerk of the court then said, I suggest, because we haven't got time to hear this in full,
okay,
that we adjourn the case.
Right, okay.
Now, that's what should have happened, and abuse of process in Malden.
Yeah.
They should have adjourned the case as soon as they realized they did not have sufficient time to hear it.
Yeah, they were trying to rush us along.
Yeah.
Yeah.
And remember, we have the right to see the evidence, cross-examine the evidence, present our evidence. They then get the right to rebut our evidence, the highest standing truth. That becomes the judgment. Otherwise, rationally, the decision couldn't have been made based upon the evidence before the court.
Absolutely.
So then, with the adjournment, I think his words were, set aside the order and adjourn it to a full hearing. So I said, no, under your powers under section 142, I require the order to be voided because it's got no authority. It's no act of the court.
Right.
And the guy sort of like looked at me, so basically we agreed whether it's set aside or voided is actually largely irrelevant. The point is, I need answers to these questions. They're wasting everybody's time.
Yeah.
So the court agreed that I'll give I resubmit now to the court the summary of everything that was submitted to the council, basically defense.
Right.
I got a month to do that, and the court has ordered them within a month to respond to that.
Right.
Now that is mega.
Yes.
What is that saying? Councils, you can't just diss this anymore.
No.
Okay. Because when we get to court, we will now get court orders to force you to answer these questions
all day long
in a full, accurate, and complete manner.
Yes.
So finally, we've got power to our notices. They must respond. If they don't respond, we get the order in the court to force them to respond. So finally, the discussion is going to be starting to take place.
Absolutely. And this is where, the whole process that we've been working on up to date and others you know, in the background as well. This is we need to force them to do their jobs properly.
Correct. And that's called moving the court.
Moving the court under the court rules.
Yeah.
Very,
and
very
guess
clear.
what that is? That's us taking responsibility.
Absolutely.
Growing up.
Yes.
And stop blaming the Freemasons
yes.
or this, that, and the other.
I mean, I'm not personally aware. I don't know if anybody else has got this far in the country, right? But I'm not personally aware of anybody that's got to this position so far. I don't know if you have.
Well, I don't know. There may be others, but
there may be others.
Getting it out and teaching people, or expressing our experience. Yeah, they can choose to do what they want.
What I was going to say, Mark, is if anybody's in this position or has been in this position, can you let us know?
Yeah, absolutely.
What happened and how far did you take it and what procedure, and just give us some details if you have heard or anybody has been in this position. But this is monumental in so many respects, because now it's not just the council that has got to answer. The magistrates have got to answer, the advisor of the court, clerk of the court, have got to answer to the court rules and what their responsibilities are. Yeah,
absolutely.
Obligations. Everybody's got an obligation.
Everybody.
Right? And we're fulfilling our obligation by attending the court,
and trying to settle the matter.
We're not even discussing the numerous amount of paperwork that we've sent to the council. At least we're turning up to the court and we're saying, well, look, okay, we'll discuss this.
Yeah, because we've got an obligation to keep the peace.
Yes.
That's our obligation, to keep the peace.
Yes.
To resolve disputes. And equally, we have the right to enforce others keep the peace.
Absolutely.
And then basically they then phoned around for a district judge. So it's not even a deputy district judge for availability.
Yeah.
So that's been relisted then for the 20th of October.
Right.
So hopefully people can see, with a bit of effort, you can start to hold people to account.
Yeah.
And then at the end, when they sort of made the order, then I just said, oh, by the way, can I just have the names of everybody here? And so he started writing down his, getting a piece of paper. I said, hang on. Here's my little notebook. Can you just put them on here? And so they were clear that there's no messing here. And without objection provided their names. Now that there didn't happen in Malden where you witnessed it, where they refused to give the name.
Absolutely.
Okay, and again, that is unlawful. There is no such thing as an anonymous magistrate.
Absolutely.
And my understanding, well, you were there, maybe better if you explain to people what happened in regards to the name.
Well, when he was asked, he refused. Point blank.
That was first with Angela.
Yeah. Angela tried to speak and ask some questions. Anyway, she got shut down and basically railroaded. Karen went next. She asked for the name. He refused point blank. She got railroaded as well. And then Chrissy fortunately remembered the case law, Regina versus Felixstowe, where, as you pointed out, there can be no anonymous JPs, justices of the peace or magistrates. Yeah. And once he recited that, the clerk,
did he respond first and say no?
First of all, he did ask for the name, and he said no, basically.
And after the legislative law,
Chrissy gave him the chance to answer.
Did he?
He said no.
Okay, and then the clerk intervened.
And then when Chrissy recited the case law, then the clerk intervened, turned around. Chrissy would remember this because he was standing there. Basically said quite loudly, "Yes, this is true," or "This is, you have to do this." And he turned around and said, "No, I've made my decision. I'm not going to provide my name."
So now with this here, you can see there are just so many breaches of authority.
Massive.
Now, any breach of the rules prejudices a party.
Yeah.
Okay. And therefore, the breach also removes them from the protection of the court.
Yeah.
When you act under the authority of the court will protect you.
Yeah.
But by refusing to follow the rule of law, you're now stepping outside.
Yeah.
And not only is the magistrate personally liable as a free agent, but in the first instant, it's common knowledge, or should be common knowledge, for a legal officer to tell them to give their names when asked.
Yes, absolutely.
And therefore, the legal officer as well recklessly misled the court by not putting the court with the relevant law, saying, first time when Angela asked, she should have intervened and said, sorry, you've got to give the name.
And that's funny, isn't it, that he was asked 3 times as well?
Yeah. Yeah. And the other thing is, did they actually present their evidence to any of them?
Didn't get that far.
No, I thought you said that Angela
tried to ask some questions.
Yeah.
And basically the magistrate was, well, you know, he did confirm that he was on his oath. I think she asked that question at the beginning. And then she was trying to ask some other questions, and he was just like, well, we haven't got time for this. And the legal advisor was saying, well, we haven't got time for this, and you know, you're wasting our time. So again,
okay, so basically they're denying her the right of self-defense, therefore that liability order has no standing.
Yeah.
But essentially everything that happened in that court after the first asking of the name where he refused to name himself, everything thereafter is void.
Yeah.
It has, you know, it's contempt of court, void ab initio.
Yeah.
So we seem to have had a lot of different the courts have reacted in different ways with this stuff.
Yeah.
Now, with the defense, we've updated the defense, and I'll be going through with Ahmed this afternoon. But basically, Ahmed, who was the first one in court sort of thing, they gave an adjournment quite rightly. In my case, they gave an adjournment, but I could have argued and said, no, we're settling this matter now. But with a bunch of magistrates, forget it. It's just a waste of time with legal officers. These people just have no idea what's going on. So hopefully with a district judge, at least we'll start to have an intelligent conversation.
Yeah.
So I'm quite happy to go in.
Yeah.
Also, the court auditor's manual should be out. We should have some people trained so we can fill the public gallery as well, so other people can evidence the ongoings. Down then, Malden, basically, they've just railroaded, ignored everything. With Teresa, we put in the defense the day before, and within an hour, the council asked for an adjournment.
Amazing.
So we're getting very different results around the country.
Of course, yeah.
Okay. And so there's no coordination yet between the courts.
No.
There's clear evidence of coordination between councils to try and shut us down.
Yes.
But we're going to have fun with that.
But the only coordination, Mark, is that they've only got one thing to say to us.
Yeah. Parliament sovereignty.
Well, free man on the land. Yeah. That's what our argument is. And then by the same token, like you just said, you know, Parliament sovereignty, they are supreme lawmakers.
That's all they got to throw at us.
Nothing. They've got nothing.
Yeah. And so just talking about freemen of the land, I suggest people go, if we can put the link to the responses of the council and our rebuttal of their responses. But essentially, with the freemen of the land and stuff like that, they call this OPCO, Organized Studio Litigants in Person or something like that.
Yeah.
And so what is fascinating in there is within all of their stuff, in this, there's one particular judgment, Mead versus Mead. And by the way, thanks, Emma, for that one. You're a goddess. Okay. Because this actually totally trashes their arguments. It absolutely annihilates everything that they're saying. Okay.
Not real. Yeah.
And now what's happened is she's provided this to us in response to a notice. I've said, gee, wow, great, I agree with you. So we have common ground now. And therefore, between the council and ourselves, that there's not in dispute. So we use it with the mirror to reflect against them. So it's brilliant. We've achieved a huge amount so far. I can tell you one thing, the magistrates courts deal with this, not always in accordance with the rules, but that's because we don't hold them to account to the rules.
Exactly.
Not a private for-profit corporation nonsense. That's all utter nonsense.
Yeah.
We've got all the evidence. And if you can't believe, memorandum of entry from the court summonses, court hearing relistings, sorry, I really don't want to waste my time with.
Yeah, people have really got to advance now. New information is being
concentrate on it.
We're providing the evidence that this is not how it works. There's so much belief out there, right? And that is preventing us, not us personally, but it's preventing you guys from moving forward.
Yeah.
Because you're stuck. You're
basically
stuck on an untruth.
But again, people always shout about evidence. Okay. If you don't want to open your eyes, apply your mind to what's before you.
Yeah.
Okay. Forget it. You're in the same thinking, which has caused the problem that you're in.
Absolutely.
The only way we're going to change this is by changing our thinking.
Yeah.
Get rid of the bloody egos. Get rid of all of this nonsense.
Yeah.
Search for the truth with humility.
The biggest issue, is us, really.
Yeah, we're the biggest problem.
We are the biggest problem, and we always will. Well,
yeah.
I think we always will be to a certain degree.
But until we start standing up for one another in what is right.
Absolutely.
As long as we continue turning a blind eye.
Yeah.
Yeah.
But the egos of these legal people they're huge. Let's face it, Mark. Yeah, because they don't want to be wrong, do they?
Of course, nobody wants to be wrong, but I mean,
always right, aren't they, Mark?
Yeah. But don't shoot your mouth off before you've got evidence, and then you don't have to fear being wrong.
Yeah, exactly.
Don't just give opinion.
No, that's right. So yeah, we're making huge advancements in this just one instance, and we've got other things.
Well, no, this is 3 or 4. It's what happened.
Well, yeah.
It's what happened to Ahmed's son in Manchester. This is starting now around getting into the consciousness of the courts, the legal advisors, all of this.
Yeah, I think a few of us are going to do another video soon. Inviting certain counsel to have a public debate.
Why not? Because what they're scared of?
Well, I've invited a certain publication on a Facebook comment as well. They're invited to this public debate and discussion. Will they all turn up?
No,
they won't, will they?
Of course they won't.
The ego will step in and go, no.
Yeah.
Mark, that's fantastic.
Brilliant.
This is a long-awaited video, and
sorry it took so long, but
listen, in the grander scheme of things, since you've been working on it,
not me, all of us,
and the rest of us, it's actually quite a short period of time, isn't it? Compared to
the big picture, people have been fighting council tax from day one, 1992.
Exactly. So, yeah, brilliant.
Okay, thanks,
Mark.